An ambulance, a wheelchair, and a child's tank-shaped stroller approach a sign saying, "No vehicles." A man with one tiny dictionary screams, "No interpretation allowed." Just read it. Fine, read it. Now tell us which one is prohibited. If answering requires anything beyond repeating those two words, congratulations. Interpretation has already happened. The real question is not whether courts interpret law. They do. The real question is whether the court can show that its interpretation came from the enacted law, or whether it stretched the law to reach a preferred result. Here is how to tell the difference. Parliament, Congress, or a provincial legislature enacts the controlling text. Courts interpret and apply that text to actual disputes. Higher courts may review the interpretation, and the legislature may amend the law if it wants a different rule. Those roles are different, but interpretation is unquestionably part of deciding cases. Statutes are general. Cases are specific. The legislature writes no vehicles. The court receives an ambulance, a wheelchair, and a bizarre stroller. Repeating the statute does not apply it. The court must determine what the words mean in their legal context, decide whether the proven facts satisfy that meaning, and make the required finding. But interpretation is not permission to rewrite the statute. The court must remain tethered to the words actually enacted. Now look at the blindfolded literalist turning the plain meaning knob while insisting, "I'm not interpreting anything." But choosing a supposedly literal meaning is itself an interpretive decision. Which dictionary meaning is plain? Did the statute provide its own definition? Is the word being used technically? What do the surrounding provisions say? Is there an exception? Has a controlling court already interpreted it? You cannot choose one meaning, ignore the others, and pretend no choice was made. Consider the phrase "will cause," which has appeared repeatedly in our discussions. Someone may isolate those words and claim they automatically establish intent, a threat, or some future legal consequence. But the phrase alone does not answer these questions. What statute are we applying? What legal element must be proven? How has that element been defined? What context limits the language? And what evidence proves that this person satisfied it? A grammatical observation is not automatically a legal finding. The court still needs the rule, the facts, and the required finding. That is why court should not become a dictionary duel. Two people can find different definitions and shout, "My definition wins." But the proper question is, which meaning controls here and why? Begin with a complete statutory text. Check for statutory definitions. Read the surrounding provisions, structure, and exceptions. Then examine controlling cases and recognized principles of statutory construction. A dictionary may help. It does not automatically override the legislature's definition, the statutory context, or binding precedent. Purpose is not unlimited either. A court cannot invent a desirable policy and detach it from the words the legislature enacted. The interpretation must remain connected to the statute. So how do you challenge an interpretation that has been stretched too far? Do not merely offer another dictionary definition. Audit the bridge from statute to order. That bridge should contain 5 solid sections. First, exact text. What precise words authorize the proposed interpretation? Second, define terms. Did the legislature define the disputed language? Did the court use that definition? Third, controlling cases. What binding authority adopted this interpretation? Is the cited statement actually the court's holding, or merely dicta, commentary, or a case involving different facts? Fourth, material facts. What evidence establishes the facts necessary to trigger the statute as interpreted? Fifth, the required finding. What finding must the court make, under what burden of proof, and did the court actually make it? If one section is loose, identify the gap. Ask, what is the textual hook for that construction? Where is that term defined? Which controlling authority adopts that meaning? What limits this interpretation from expanding indefinitely? Which proven facts bring this case within it? And finally, what finding is the court making? That is how you challenge overreach. You are not making the losing argument that courts are forbidden to interpret. You are showing that this particular interpretation used the wrong text, ignored a definition, relied on non-controlling authority, overlooked an exception, lacked supporting facts, or skipped the required finding. Finally, get the interpretation receipt. A judge announcing "that's what the law means" does not end the examination. Ask for the itemized basis. What statute was used? What interpretive method was applied? What controlling authority supports it? What facts were relied upon? What finding was made? If a receipt line is blank, identify it. If the court relied on a disputed fact, identify the missing evidence. If it used a dictionary while ignoring a statutory definition, point to the enacted definition. If it relied on a case, compare the actual holding and material facts. If it skipped a required finding, ask for that finding and its basis. Depending on the jurisdiction and proceeding, this may be raised through an objection, motion, written argument, request for reasons, or appeal. The essential point is to place the problem in the record. Higher courts review preserved rulings, evidence, findings, and legal errors, not who delivered the most emotional courtroom speech. The record, not the speech, is the product. Here is the entire lesson. The legislature enacts the text. Courts interpret and apply it. Plain meaning is an interpretive method, not the absence of interpretation. Dictionaries may assist, but statutory definitions, context, structure, and controlling authority determine what governs. And if a court stretches the law, do not merely shout another definition. Expose the missing legal or factual connection. Ask for the source. Test the bridge. Demand the finding. Because the law does not apply itself, but neither may a court lawfully turn interpretation into invention.